All right, I hereby call this meeting to order. This is the Town of Highland Beach Special Magistrate hearing for code enforcement. The cases will be called in the order in which they appear on the agenda. The town will present its testimony and evidence first. You'll have an opportunity to review any of the evidence presenting by the town and ask questions of any of the town's witnesses, after which time you can present your own testimony and evidence. This is a quasi-judicial hearing, which means that the formal rules of evidence do not apply here. However, all testimony is taken under oath under penalty of perjury. So if you're going to testify today, or you think you might testify, there's a possibility that you might testify. I'd ask that you rise and raise your right hand so the deputy clerk can swear you in.
By the authority vested in me as a notary of the state of Florida, do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. You may be seated.
All right, first order on the agenda is the approval of the minutes of February 11th, 2025. They are hereby approved on this 8th day of April, 2025. All right. All right, first item on the agenda is case number CC 24533.
My name is Adam Osowski. Try that again. Good afternoon. My name is Adam Osowski, Town of Highland Beach Code Compliance Officer, and I've been previously sworn in. The property address is 3420 South Ocean Boulevard, 3Q. I inspected the property on December 26, 2024. The violation cited on today's agenda is 30-122A, building permits required. The permit was submitted on February 5th, 2025. The notice of violation was served by posting on January 14th, 2025. After certified mail was sent on December 26, 2024. The respondent was given 30 days to come into compliance. The notice of hearing was served by certified mail sent on March 1st, 2025 and hand delivered on March 5th, 2025. Prior to today's hearing, I re-inspected the building records on February 11th, 2025, and the violation has been corrected. The permit was issued on February 7th, 2025. I have submitted the following evidence, which includes proof of service, supporting documents, and photographs. The town recommends that the respondent be found in violation of the town code as alleged in the notice of violation. The town is asking to assess prosecution costs in the amount of $250 payable within 14 days.
Is there anyone here on behalf of the respondent, Dennis and Tatiana Petrov? Please come on up.
Your Honor, thank you for the opportunity to speak today. My name is Denis Petrov. I'm a new homeowner of the condominium at 3420 South Ocean Boulevard, apartment 3Q in Highland Beach. I'm here today in regard to a citation issued on December 26, 2024, concerning construction activity for which, at the time, the proper permit has not been issued. I want to begin by assuring the court that it was never my intention to disregard or violate any local building codes or permitting procedures. I hired a licensed contractor, Gruenthal Construction, to manage the renovation project professionally and in full compliance with the law. The permit application was filed by my contractor on January 14th, 2025. Unfortunately, we later learned that the town requires the drawings to be submitted electronically with a certified digital signature. January 14th is within 30 days. That was from the time the citation was issued. The initial drawings, unfortunately, were done by hand, and by the time we adopted the submission to meet these digital requirements, additional delays occurred due to reported malfunction in town's electronic review system. The issues were outside of my control, and we did every possibility to move the process along. Ultimately, the permit was approved and issued on February 7th, 2025. I would like to bring to the court's attention that the original citation was issued just after Christmas, during the holiday season, and at a particular sensitive time for my family. My wife was pregnant, and we were preparing for the birth of our daughter, who arrived on February 26th of this year. As you can imagine, this was a great personal stress and responsibility.
Well, congratulations.
Thank you. We have a new resident of Highland Beach. Her name is Anna. And we were doing the best to manage everything responsibly, including ensuring the renovation followed all appropriate steps. In light of circumstances, the holidays, the pregnancy, this miscommunication regarding permit requirements, and the delay with the town electronic system, I respectfully ask the court to understand and leniency. We have acted in good faith, worked with licensed professionals, and ultimately ensured that everything was properly permitted and brought into compliance. Thank you again for your attention. And I do
Thank you,
have
Mr.
a
Petrov.
supporting letter from my, from not attorney, from a contractor
Yeah.
confirming.
Mr. Petrov,
yes, sir.
I do appreciate the statement. The city has not asked me to fine you here.
Okay,
What
thank
they have asked me to do is to find that you were in violation and to assess the court costs for the proceeding. And that's, that's not nothing. That's $250, but it's not a fine. They're not seeking to punish you for this.
Thank you. Thank you. I appreciate
With
it.
all of that said, I do think it's important to point out the major consequence of me making that finding is not that I'm going to fine you today, is that if a violation occurs in the future, you could be subject to more significant fines that happen much quicker.
I understand, sir.
And so, so all I'm going to do today is find that there was a violation and you've come into compliance and assess the court costs. But it is important in the future because, I mean, it has no real meaning right now, but in the future, if this same violation occurs, it could be much, much more severe. So you should definitely make sure that it doesn't happen again.
Absolutely. That's
All right.
loud and clear, sir. Thank you.
All right, in case CC 24533, I make the following findings of fact and live phone. This notice is sufficient upon the property having been in violation has since come into compliance after the required compliance date. I issue no fine today, but I assess court costs in the amount of $250 payable within 14 days. Thank you for coming in.
Thank you.
April 22nd.
April 22nd.
Thank you.
Sorry. I would, yeah, got to remember that. Date certain here. Date certain here. All right. So you'll always remind me, I'm sure. All right. Next case is CC 24539.
My name is Adam Osowski and I've been previously sworn in. The respondent is Michelle Orris. The property address is 3300 South Ocean Boulevard, Unit 923C. I inspected the property on December 30th, 2024. The violation that remains as cited on today's agenda is 30-122A, interior remodel without permits. The permit was submitted on February 7th, 2025. It is currently waiting on the customer to obtain an additional sub-permit, add to existing plumbing permit. The notice of violation was served by posting on January 7th, 2025, after certified mail was sent on December 30th, 2024. The respondent was given 21 days to come into compliance. The notice of hearing was served by posting and certified mail sent on March 1st, 2025. The certified letter was returned unclaimed on April 1st, 2025. Prior to today's hearing, I re-inspected the building records on April 2nd, 2025, and the violations continue to exist. I've submitted the following evidence, which includes proof of service, supporting documents, and photographs. The town recommends that the respondent be found in violation of the town code as alleged in the notice of violation. The town asks for 30 days to achieve compliance or a $250 a day thereafter. The town is asking to assess prosecution costs in the amount of $250 payable by the date set for compliance.
$30 days is May 8th.
Yes.
Is anyone here on behalf of the respondent, Michelle Orris? Coming up, sir. Can you tell me your name, please?
Yes, sir. My name is Armando Rodriguez. I'm representing Michelle Orris on behalf of the company New Homes Innovation Group, the general contractors that will be.
You're the
Good.
general contractor hired by Ms. Orris?
Yes.
So the town says that you're missing a permit and they want to give you 30 days to get it. Is that accurate?
Yes, that is accurate. Yeah, we've been back and forth with the city on multiple different stuff. Finally, we got everything approved. The last thing that now they want is for the plumbing. We're not changing any plumbing. And then I went and spoke with somebody. They said all I had to do was on page A3 at the scope of work, submit, that should be fine. I submitted that and they're like, no, they want us to do a sub permit on that. So I talked with a couple of plumbers to get some quotes for her so that they can submit that. That should be done this week. So
So 30 days is a sufficient amount of time?
yeah,
for you to
yes,
come into
yes,
compliance?
yes, Your Honor. That should work. So
Anything else you want me to know?
no, right?
All right. I'm going to give you the 30 days. Do keep in mind that there's a potential fine of $250 per day if you don't comply.
Yes, sir.
So do make sure that once you're coming to compliance, that you reach out to the code officer and let them know that you're in compliance.
I will do, sir.
All right.
Thank you.
And in case CC 24539, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of the listed code section for failure to obtain a permit for work. Respondent is given 30 days to come into compliance, or a fine of up to $250 per day may issue. The date certain there is May 8th, 2025. I assess $250 in court costs payable by the May 8th deadline. Thank you, sir. All right, next case is CC 2519.
My name is Adam Osowski, and I've been previously sworn in. The property address is 3912 South Ocean Boulevard, Unit 702. I inspected the building records on January 8th, 2025. The violations that remain as cited on today's agenda are 30-122B, permit BR 21-0156, bathroom, kitchen, and closet remodel has expired. The permit was originally issued on November 3rd, 2021. It is currently expired due to missing inspections and unpaid fees. The notice of violation was served by certified mail sent on January 8th, 2025. The respondent was given 14 days to come into compliance. The notice of hearing was served by posting on February 24th, 2025, after certified mail was sent on February 19th, 2025. Prior to today's hearing, I re-inspected the building records on April 2nd, 2025, and the violations continue to exist. I have submitted the following evidence, which includes proof of service, supporting documents, and photographs. The town recommends that the respondent be found in violation of the town code as alleged in the notice of violation. The town is asking for 30 days to achieve compliance or be fined $250 per day thereafter. The town is asking to assess prosecution costs in the amount of $250 payable by the date set for compliance. I did speak to the respondent this morning. He's unable to attend today's hearing for medical reasons. But he does agree, he's asking for 30 to 60 days to come into compliance.
Any reason to believe that this couldn't be done in 30 days?
No, sir.
What's your thought on his request for 30 to 60 days?
I believe 30 days is more than enough time to get everything done.
Anything further?
No.
Well, for the record, is anyone here on behalf of the respondent? All right. In case C 2519, I make the following findings of fact and law. If I notice is sufficient, I found the property in violation of 33-122B. I give the respondent failure to obtain the proper expired building permits. I give the respondent 30 days or until May 8th, 2025 to come into compliance, or a fine of $250 per day may issue. I hereby assess costs the amount of $250 payable on May 8th. All right, CC 2541.
My name is Adam Osowski, and I've been previously sworn in. The respondent is Townhouses of Highland Beach. The property address is 2575 South Ocean Boulevard. I inspected the property on January 14th, 2025. The violation that remains as cited on today's agenda are 6-27, administrative amendments to the Florida Building Code, and 110.9 parentheses 5, Town of Highland Beach Administrative Code, Chapter 1 for the 7th edition, 2020 of the Florida Building Code. The association has failed to comply with the requirements regarding the recertification of the building by failing to submit the required concrete restoration permit. The notice of violation was served by certified mail sent on January 14th, 2025. The respondent was given 21 days to come into compliance. The notice of hearing was served by certified mail sent on February 5th, 2025. Prior to today's hearing, I re-inspected the records on April 2nd, 2025, and the violations continue to exist. I have submitted the following evidence, which includes proof of service, supporting documents, and photographs. The town recommends that the respondent be found in violation of the town code as alleged in the notice of violation. The town is asking for 30 days to achieve compliance or be fined $250 per day thereafter. The town is waiving prosecution costs in this case. And I have been in contact with the building manager throughout the process, and she's present to explain their status.
Is that you? Come on up.
Good afternoon. My name is Mark Brecker. I'm the president of the Board of Directors of Townhouses. With me is Daniela Ehrlich, who is our manager.
I'm sorry, can you say your last name again one more time?
Brecker, B-R-E-C-H-E-R. And while I am a licensed attorney, I'm not appearing today in that capacity. I am appearing as president of the board.
That is an
And
important distinction.
very important. And while I haven't appeared in front of a court in over a year, I appreciate the opportunity. The condominium board has been very vigilant in trying to achieve what the statute requires. We were, I think, early in submitting the milestone report. Unfortunately, after that was submitted, we had some restoration issues to the building that really required a lot of time. We had leaks in our many units in our building. We actually had a care construction company that did that, and that consumed a lot of time, money, and effort by the board. We were late in getting bids for the milestone repairs, but we hired an engineering company, Swaysland Engineering Company, to get bids. We did get bids in March. The engineering company was evaluating those bids. And while it took a little bit of time, they have approved what the bid should be. The bids have been accepted by Care Construction. We expect them to submit permits next week, if not sooner. So we are in compliance. We appreciate the town's waiving prosecution costs. And 30 days is more than sufficient for us to come into compliance. And we appreciate the town's indulgence in this matter.
All right, well, since you're both in agreement, I really don't need to hear anything further unless you want to put something on the record.
No, I think.
Yeah, okay. So you're both in agreement that 30 days is sufficient amount of time? All right. All right, in CC 2541, I make the following findings of fact and law. I find notice is sufficient. I find the property in violation of illicit code sections. Hereby give the respondent 30 days or until May 8th, 2025 to come into compliance, or a fine of up to $250 per day may issue. I waive prosecution costs.
Thank you.
And we're back.
Mm.
Go ahead.
All right, this is case number CC 25-49. My name is Adam Osowski, and I've been previously sworn in. The respondent is Townhouses of Highland Beach Condo Association. The property address is 2565 South Ocean Boulevard. I inspected the property on January 16th, 2025. The violations that remain as cited on today's agenda are 110.9 parentheses 5 and 6-27. The association has failed to comply with the requirements by not obtaining a concrete restoration permit. This is a second building. The notice of violation was served by certified mail sent on January 16th, 2025, The green card was returned signed on January 23rd, 2025. The respondent was given 20 days to come into compliance. The notice of hearing was served by certified mail sent on March 4th, 2025. Prior to today's hearing, I re-inspected the building records on April 7th, 2025, and the violations continue to exist. I've submitted the following evidence, which includes proof of service, supporting documents, and photographs. The town recommends the respondent be found in violation of the town code as alleged in the notice of violation. Again, the town is asking for 30 days to achieve compliance or be fined $250 per day thereafter. The town's waiving prosecution costs in this case. And again, I've been in touch with the building manager and the status of their two buildings.
Mr. Pritchard, you want to say anything?
No, Your Honor, I will I'll affirm what I just said
Okay.
earlier.
Just so I'm clear, the reason this is two separate cases is because this is two buildings on this, two separate buildings that require their own permits on the same property. Is that accurate?
Correct. They're two separate buildings and they have two separate PCNs.
Fair enough. All right. Case CC 2549, I make the following findings of fact and law. I find notice is sufficient. I found the property in violation of the listed code section 627 and Florida Building Code 110.95. I give the respondent 30 days to come into compliance or a fine of up to $250 per day may issue. I hereby waive prosecution costs. Well, unless I'm misreading the agenda, I believe that's it for us, right? All right. Seeing no further business before us, this meeting is hereby adjourned.